start. Special leave granted. Does an action of the superior against a female employee which is against moral sanctions and does not withstand test of decency and modesty not amount to sexual harassment? Is physical contact with the female employee an essential ingredient of such a charge? Does the allegation that the superior tried to molest a female employee at the place of work not constitute an act unbecoming of good conduct and behavior expected from the superior? These are some of the questions besides the nature of approach expected from the law courts to cases involving sexual harassment which come to the forefront and require our consideration. Reference to the facts giving rise to the filing of the present appeal by special leave at this stage is appropriate. The respondent was working as a private secretary to the chairman of the Apparel Export Promotion Council, the appellant herein. It was alleged that on 12/8/1988 he tried to molest a woman employee of the council, Miss X, name withheld by us, who was at the relevant time working as a clerk cum typist. She was not competent or trained to take dictations. The respondent, however, insisted that she go with him to the business center at Taj Palace Hotel for taking dictation from the chairman and type out the matter. Under the pressure of the respondent, she went to take the dictation from the chairman. While Miss X was waiting for the director in the room, the respondent tried to sit too close to her and, despite her objection, did not give up his objectionable behavior. She later on took dictation from the director. The respondent told her to type it at the business center of the Taj Palace Hotel, which is located in the basement of the hotel. He offered to help her so that her typing was not found fault with by the director. He volunteered to show her the business center for getting the matter typed and taking advantage of the isolated place again tried to sit close to her and touch her despite her objections. The draft typed matter was corrected by Director Finance, who asked Miss X to retype the same. The respondent again went with her to the business center and repeated his overtures. Miss X told the respondent that she would leave the place if he continued to behave like that. The respondent did not stop, though he went out from the business center for a while. He again came back and resumed his objectionable acts. According to Miss X, the respondent had tried to molest her physically in the lift also while coming to the basement, but she saved herself by pressing the emergency button which made the door of the lift to open. On the next day, that is on 16th August 1988, Miss X was unable to meet the director personnel for lodging her complaint against the respondent as he was busy. She succeeded in meeting him only on 17th August 1988 and, apart from narrating the whole incident to him orally, submitted a written complaint also. The respondent was placed under suspension void an order dated 18th August 1988. A charge sheet was served on him to which he gave a reply denying the allegations and asserting that the allegations were imaginary and motivated. Sri J. D. Giri, a director of the council, was appointed as an inquiry officer to inquire into the charges framed against the respondent on behalf of the management with a view to prove the charges. As many as 6 witnesses were examined, including Miss X. The respondent also examined 7 witnesses. The inquiry officer, after considering the documentary and oral evidence and the circumstances of the case, arrived at the conclusion that the respondent had acted against moral sanctions and that his acts against Miss X did not withstand the test of decency and modesty. He therefore held the charges leveled against the respondent as proved. The inquiry officer, in his report, recorded the following amongst other findings: 8.1. Intentions of Sri A. K. Chopra were ostensibly manifested in his actions and behavior. Despite reprimands from Miss X, he continued to act against moral sanctions. 8.2. Stop.